Good evening, everybody. Happy Wednesday, 6 p.m. Eastern Time. I'm attorney Brian Burke, just like the sign says below me. I am an immigration attorney with Shihab Burke here in Dublin, Ohio, and the reason I'm here tonight is, the reason I'm here every Wednesday night, is to answer your questions about fun and interesting immigration issues and sometimes taking on a topic of my choosing. Now, today, we're not doing that. We are doing all questions. So, looking forward to seeing what kind of questions you guys have, and so one, start getting those in. Two, I have some questions that I've already gotten from our website, immigrationquestions.us. I'm going to do a little plug here for immigrationquestions.us right quick. Immigrationquestions.us is our website where you can go during the week. Oops, oh, my graphic got messed up. Immigrationquestions.us is the place where you can go in the week to ask us immigration questions. If the mood suits us, we will put those live up here on YouTube, answer them live. Otherwise, we will shoot you an email if we don't have the time to get to them live here. That's sort of our promise to you. So I'm gonna go put this thing back here, the main view here, and guess I'll say, get those questions in because we're anxious to take them. I'm anxious to take them. I'm used to saying we because I'm usually here with Sam. But bottom line, I'm going to start going through the questions that we have sort of built up here from immigrationquestions.us. Let's see what we have here. So, a great one. What kind of questions can I expect during an employment-based green card interview? So, as I view any sort of green card interview, be it employment-based or family-based, I think they're sort of broken down into three parts. One is sort of verifying your personal biographic information as appears on your I-485 form. That's like, you know, what's your name? Where were you born? When were you born? Where do you live? Who do you work for? All the stuff that appears in the first 10 pages or so of the I-485. Next part, really about those security questions. Those of you who filed I-485 know that around page 10 or so of the form, there's a big, long list of security questions like, are you a terrorist? Were you a Nazi? Have you ever claimed to be a U.S. citizen? Have you ever worked without authorization? Ever been denied a visa? There's a part of the interview where basically that officer is going through your case to verify that your answers to those questions. They're going to ask you those questions. You're going to say yes or no. So a good chunk of the interview is verifying what is on the I-485 form. Is it accurate? Is the form you gave to us, is that going to align with what you say right now? If not, they fix it during the interview. But the important part, the interesting part, the part that varies for everybody, is when they get to the spot in the interview, usually after they take care of those first two items, the basic biographical information and the security information, and start asking you about the substance of your green card case. And that's where they can really kind of ask you anything. They might ask you, you know, what are your duties for your job? What kind of hours do you work? How did you get hired by that company? Who do you report to? Things get a little bit more interesting if you're in the world of IT consulting, as so many people on H-1B visas are. You know, they can really kind of ask you about, well, they're generally paranoid about IT consultants in general. And they might get really kind of interested in, you know, were you ever benched by your H-1B employer? Have you always been working for a client? Has there ever been a time when you, where you weren't paid properly? Because what they're really looking for is, have you complied with your immigration status in the past? And is that employment offer that they have for you a real, legitimate one? So, you know, if you have an employment-based interview, and I expect more of them to come up because change of administration, more scrutiny, more interviews for everybody, talk to an attorney about what to expect. Basically, a guy like me will look over your case and point out the sort of things I might consider flags and talk to you about them, talk about how you might address them if they come up. I'm going to hit one more from what we have from immigrationquestions.us, but don't worry, keep those questions coming in live because I'm excited to answer them. So, what happens to my priority date if I switch employers? So, that is a more complicated question than you might think. What happens to your priority date depends upon where you are in the immigration process through your employer. So if you have filed a labor certification, for those of you who aren't aware, the date your labor certification is filed, that's going to be your priority date. But that labor certification based priority date is not secured, not yours, until an I-140 is approved on your behalf. So with the processing times of I-140s, labor certifications right now, the priority date for your case can really be like, a year and a half or so or more before your I-140 is actually approved. So I guess the thing to take away is this. Until your I-140 is approved, you don't have a priority date secured. And if you're asking me, should I switch? If you have a green card in process, I'd say wait until that I-140 is approved. And better yet, 6 months after that I-140 is approved, because you get benefits associated with that as well. Let's see here. A really good question from Subhashri here. Any benefit in giving birth in Colorado, blue state, over red state, Texas, with the ongoing birthright citizenship issue if the due date is in August to September? So it's a good question. So on the issue of birthright citizenship, I believe this issue is going to keep on getting kicked down the road and kicked down to the road until it reaches the Supreme Court. And the Supreme Court is going to make a decision, and that decision from the Supreme Court is going to govern what the result is for the blue state Colorado, red state Texas, and everywhere in between. And I guess the short answer is this is a big political issue. There is going to be eventually a uniform decision. And I think that this situation is developing so much that it's really hard, that my answer to that question today could change tomorrow, would be my honest answer. So my honest answer is, I don't think there's a good answer to that question right now. I think realistically there is a chance that this issue could be resolved by the Supreme Court before that date of birth, and meaning it wouldn't matter what state you're born in, Colorado or Texas or anywhere else, the result would be equal. So I guess the short answer is watch the Supreme Court, and that's when we'll or watch the appeals process for the cases that are out there, and that's really where you're going to get the answers there. So I'm going to keep on going through those questions we have from our website, immigrationquestions.us. That's immigrationquestions.us. Keep your questions coming in live, because I'm going to be answering those too, because they are an absolute joy for me to answer. Let's see here. A great question here. Can I work for a new employer on H-1B while waiting on a green card from a previous one? So the way I interpret this question is, 10 years ago, let's presume you're in the India backlog. 10 years ago, I filed a green card through Company A, and great. My priority date comes current. I file an I-485, and my I-45 for some people has been pending, like 4 years at this point, right? Over 4 years, getting close to 5 now. And maybe you want to try something different with another H-1B employer. That's fine. You are allowed to do that. It shouldn't be an inherent problem that you are working for another employer in H-1B status while waiting on your green card through another employer. However, USCIS officers that review cases, that review green card cases, not a lot of them are super, let's say, experts in the nuance of that ripple of the rules of employment immigration, and they might find it confusing that, you're with employer B, but your green card is through employer A. And realistically, as an immigration attorney, I'd be questioning. I'd say, well, how long have you been with employer B? Is your future really with employer A, or is it with employer B now? And in that scenario, basically, you might want to consider filing a supplement J. So the short answer is, there's no requirement that you be employed with your green card I-485 sponsoring employer until your case is approved. And I've had clients do that, and basically they tell me, Brian, my green card was just approved. What do I do? Go back to your employer that sponsored you. Great, you're allowed to do that. But just keep in mind that that the government might find that more interesting than more conventional scenarios where you're working for that employer pursuant to H-1B and you are pursuing a green card through that employer at the same time. Let's see here, going through our big list of immigrationquestions.us questions. So let's see here. Maybe this is sort of an amalgamation of a couple questions we've commonly gotten, because I've been answering this question a lot lately because there's some paranoia regarding visa stamping in general. But what are the risks of visa stamping delays at U.S. consulates abroad? Now, I talked to a lot of people don't have problems with visa stamping, and a lot of people don't even talk to an immigration attorney before visa stamping. And that's fine, great, no problems. But people usually come to me asking visa stamping questions when they know they have a problem such that they might be required to go for visa stampings. And here are my I'm gonna start with the H-1B scenario first. In the world of an H-1B visa, my worry for a delay in stamping is it going to kill your job? And this is the most true thing for people in the world of IT consulting. Imagine it. You know, your employer, your H-1B employer, your IT consulting employer, they're happy with you because they're making money off of your consulting work to a client. That's what consulting world's all about. But there's that client out there. That client out there says, gee golly, I need this person back in the United States. And eventually, you know, when your visa stamping is delayed, the big worry for me is that the client's going to become impatient. They're going to say, we need somebody to fill this role. It can't be done outside of the United States forever. Got to get somebody back here, and they replace you on that project. And that's something, a very realistic concern in the world of IT consulting. But honestly, it's same in the world of any H-1B role. You have a job in this country because you are needed. Because nobody's hiring you for charitable reasons. They're hiring you because they have a niche they need you to fill in the company. And this happens, I just was dealing with this sort of issue with a civil engineering firm a couple weeks ago. That client said, Brian, we have this new employee, we're really excited about him, but right after he gets approved, you know, with our company, he wants to go for stamping in his home country abroad. And I said, guys, well, he's allowed to do it, but right now the stamping climate is really strange. Of course, it's right around the time the new administration came in, so it was really kind of a lot of stuff up in the air. And I just sort of warned everybody involved. It's the classic thing I was taught the first day of an immigration attorney. It's who's guaranteed to be able to enter the United States. It's only U.S. citizens with a passport in hand. And for everybody else, you know, it's a gamble until you're through customs. So for H-1B folks, it is, you know, if that delay can really screw up your employment in the United States, really cause a need for your employer to find somebody else, and then suddenly, you know, who cares if the consulate resolves this 6 months later? If you don't have a valid H-1B to go back to, that's where you really have a problem. So I also sort of think about this, I just talked about this just today with somebody who was on student status, who had a status issue they need to have corrected. And the problem is for students right now, everything we're hearing is it's tougher to get appointments, more scrutiny on students, and fundamentally the same thing. Your student visa status requires you to be in the United States attending school at certain times. If you can't get back to school, it can kill, you know, your degree program, it can kill any, you know, CPT or OPT opportunities. That's really the issue that I worry about there. It's very similar, I guess, to the H-1B issue, is that opportunities in the United States are time sensitive, and the consulate being slow on that is something that really, you know, worries me. One of the headlines I read recently is that there's been layoffs at the Department of State. I didn't really get into too much detail about where those layoffs were, but I think it was 2,000 or 2,500 employees, and my attorney brain gears are going, I wonder how that's going to affect operations of the consulate. Even if it's not people who are doing interviews abroad, if these are people who are doing, say, I don't know, research regarding visa applications, trying to figure out whether it's a good idea to issue that visa, those sort of folks, if they're impacted, that could impact people with interest in visa cases. Yeah. So gonna keep on going down the list here, seeing what kind of questions you have here. Let's see here. Ooh, a classic sort of employment-based green card question, and I do love employment-based green card questions. Is it a problem if my job duties have changed since the filing of the PERM? So, Your PERM, and really the associated I-140 is what's more important here, represent an offer of employment from your employer that you can't take until there's a green card available to you, until your priority date is current. And if you're from some backlog country like, China or India, or just in a category that's, maybe a little bit more backlogged than others, there's a realistic concern that the nature of your employer's needs of you and your present job can change between the filing of the PERM and when a green card's available for you. And that becomes a problem when you go to file I-485, because when you submit that I-485, you have to submit along with that I-485J. And I-485J is sort of a great big handshake between you and your employer. Your employer is saying, I-140 job, still good, still available, and I'm willing to take it. And an inevitable question arises for me that says, can you guys submit this I-485J in good faith if, this PERM was filed 10 years ago when you're a software developer, and now this person's the vice president of software development? And my answer to that is you might have to reconsider visiting the PERM. Now, in this interesting ripple is the portability rules. After you have filed your I-485, the portability rules allow changes of your work through submission of Supplement J to a same or similar occupation and allow your I-485 to continue without a new PERM and new I-140. Great, fantastic, I love it. And they even allow you to do that jobs within the same employer. So it's really, there's some versatility there, but it's, in my mind, it's can you sign off on that I-485J in good faith? And if you can, then changes of, little bits of changes aren't really a problem. Let's see here. Let's see what kind of live questions we have here. Oh, there's a couple I've missed here. My question list wasn't scrolling. Let's see here. Hi, 601 was approved for a crime that makes you deportable, and AOS approved, which is better, N400 or I-90 application. So I'm going to talk briefly about this. These things, Peace on Earth, are really sort of fact sensitive, and I'm going to say I probably won't go too in depth here. So for those who don't know, I-601 is an application for a waiver of grounds of inadmissibility. And basically, if you have a ground of inadmissibility, you can't get a visa to the United States or get a green card, right? Now, bottom line is if you, again, I'm trying to answer the question that Peace on Earth here is really asking me, but it sounds like Peace on Earth here got a green card out of this. And great, you're a permanent resident, and you don't need to, nobody needs to become a citizen. But if you are at the end of your green card validity period, you need to renew that green card. You need to have evidence of your permanent resident status. So basically, if that waiver of ground admissibility was waived, I don't think it's likely that comes up in the future, but it's the sort of thing, these things are very fact sensitive, and we are in strange and interesting times. I think that's the sort of thing you really need to sit down with an attorney and talk about it. Here is a question here from Love. What country is being allowed to have a tourist visa to come to the United States? So the answer is most of them, with a few exceptions. So let me see, executive order travel ban. So basically, the general rule is most people from countries around the world can come to the United States applying for a visitor visa, so long as the U.S. government, the U.S. consulate can be made happy that they're eligible for a visa. Great. But the incoming administration, or rather the existing administration, the Trump administration, back on June 4th, issued an executive order that restricted the issuance of a variety of visas to people, and I'm going to sort of explain to you the countries where you might have issues now. And I'm just pulling up the executive order right now. Let me see. Afghanistan, Burma, Chad, let's see here, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, and those are countries where you're not going to be able to get a visitor visa from. Let's see here, Iran, Libya, Somalia, Sudan, Yemen. These are all countries on the list. Those countries up there actually have a full suspension. There are more countries on the list that that's sort of a partial suspension, but B visitor visas will be covered for these: Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, Venezuela, and that's the end of the list. So if your country is not on that list, no visitor visas. Now, one thing to think about though, because I don't think I've been asked this question from somebody from one of those countries yet, but what if you really want somebody to come to the United States from that country to visit you because you have family from there? What are your options? The first thing that would come to mind, and this is the sort of thing I'd really say talk to an attorney about, is consider humanitarian parole. Obviously, scrutiny is going to be big on these countries. It is already, basically there's an executive ban, but somebody from that country might be able to get humanitarian parole, for example, if they have a sick relative in the United States. Again, this executive order is as non-immigrants, and parolees are not non-immigrants. It's not ideal to come to the United States as a parolee, but that's the sort of, if you have that sort of issue out there, that's the sort of thing I really might start thinking about. So, hey, this is good news from Suresh. Thank you, Brian and Sam. I got my green card this week. I'll pass pass it on to Sam. He may be watching right now. 15 years of H-1B ends here. Following your channel for the last 3.5 years, and you've answered many of my questions. Thank you for all your support. Suresh, congratulations. Long road. It always makes me happy when I hear it. I just got an email from a client today who just got his I-485 approval notice as well. And you know, one of the best parts of being an immigration attorney is that the work, especially the work we do, employment-based, it is just, you know, it's happy work. It's people come to this country to work hard. You know, if you hear in the media, if you hear a talking head somewhere, people always say, you know, I have no problem with people coming to the United States. I just wish they came here legally. Well, you're the people who are doing it legally. You're it. So happy for you so much. 5 years for citizenship, Suresh. Think about it. Let's see here. A question live here from AN. Can I work when my H-1B extension is pending? I worked for more than 240 days when pending and received approval not for 3 years, but only a few months, and I left the country within 180 days. So this is actually a very, very interesting question. This really depends upon how as I interpret the rules and how I've read the rules in the past, this is dealing with a question of two rules. There's a rule called the 240-day rule, and there's also a rules called the portability rules. And a 240-day rule provides that while you have an extension pending, certain types of extensions pending, you can work for 240 days beyond the expiration of your I-94. Whereas if there's other spots in the rules that suggest that you can work during the entire period of the pendency of your case, but it really depends upon how that case was filed. But it seems like you're not in the country right now, Anne, and you're back now, considering there's a question, will this be an issue in the green card process? So this is sort of an issue that requires some sort of research, maybe a FOIA request for your H-1B in question, and then sort of, you know, having a conversation about how the law reads on this. But if you've traveled since then in good faith, one of the things that come up that might protect you in the context of a green card application is INA 245K, which I won't get into the details of it here, but it's a rule that provides that they only really consider your immigration issues since you last entered the country. Well, I'll say basically travel outside the country and coming back might sort of fix prior status issues relating to your H-1B is the bottom line. I won't go into too much detail on INA 245K. So here's a question from somebody with whom I'm real sympathetic for Ranyan. Ranyan says, we filed an MTR for an erroneous denial of an I-45 online case status, and case status says decision made. Does it mean the MTR only, or is it about I-45? Letter not received after 7 days yet, anxious. So, I honestly don't have the answer to that question for you. Part of me being good at my good at my job sometimes is admitting when I don't know something. So my best answer for you, Ranyan, is to wait for that notice to come in the mail. Ultimately, if it says decision made on your I-45 case, typically USCIS online case tracking will tell you the date an action is taken. I haven't seen your specific notice, so I can't really comment on it. But basically, typically it'll say, on date XYZ we took action ABC on your case. But I'm not sure if you're talking about the receipt notice for the MTR or the receipt notice for the I-485. But the good news for you is, probably within the next 7 days you'll have whatever decision they've issued on that case. I will cross my fingers for you. So what is the current I-485 processing time after priority date becomes current? My priority date is March 1st, 2013. So every time I see a priority date, I instinctively go to the visa bulletin and take a look and see what it's saying, because I will admit that I don't have in my head the visa bulletin priority date. So the name like Akash, though, and a priority date like that, there you go, there's Akash filling in the details. Current in EB3 since April. So my reasonable answer is, I presume your I-485 has been pending for a long time, probably since 2020, 2021, like that. The answer is, there's not a clear answer. I have had people literally as soon as their priority date comes up, bam, USCIS approves their I-485, and for some, I have taken months. I think maybe the better question for you is, how can I give USCIS a gentle prod and ask them to move on this? And the answer is, find an excuse to send them a letter. Historically, I've sent letters to USCIS reminding them that, hey, my client's priority date's current, appreciate if you take action on this case. Thank you very much. A very short version of what that letter would say. Another thing you can do is see if your case is eligible for service inquiry. Processing times on employment-based I-485s are weird. If you go online, it's going to say the average processing times for a case are XYZ, but odds are your case is well beyond that, because again, probably pending for years and years at this point. If you go to the USCIS case processing times, you put in the filing date of your I-485, you might be able to see whether you're eligible for a service inquiry. And it might be possible to do that. And that's really kind of your best options. Another thing you could think about is contacting a congressperson, but usually those guys can't move a case faster without a good reason, like to expedite it. Ultimately, when things start getting serious, that's when you start thinking about mandamus actions in federal court, because they can't sit on a case forever. With a priority date like March 1st, 2013, I don't really think you're in much danger of retrogression right now. So obviously you have time to wait, but darn it, you want your green card, and I sympathize with that. Well, I'll answer all comments. Good live stream. I see on YouTube more immigration attorneys are doing live streams. That's good for business for sure. Sam and I started doing YouTube because it was COVID and everything was kind of slowed down, and we were, looking for something to do. I think for us, it's a really fun way to, test us and keep us on our toes and keep us on the pulse, as it were, of what's going on in people's minds in the world of immigration. Because one of the big frustrating things about U.S. immigration in general is that people want information, they want clarity, and U.S. immigration is sometimes cloudy and gray, and we try our best to give more accuracy and clarity to people. I'm going to hit up a few more questions from immigrationquestions.us here and see what we get. I'm going to maybe go a little bit longer than 6:30 because I like answering questions. Here's one that sort of actually just came in today. I worked without authorization as a student. How can I fix it? So people who are familiar with student visas know that, student work is really, well, they might know that student work is really complex. There's on-campus employment, like in the campus bookstore or in a cafeteria or that sort of thing. There is CPT that might allow you to do an internship while you're in school. And there's post-employment, graduation OPT and STEM OPT for people in STEM fields. But when you walk outside the rules of that, you kind of break your student status. Working without authorization puts you in violation of your status, and the question is, what can I do? Well, those people might be aware that students might be eligible for reinstatement. Reinstatement is the policy essentially says if you break your student status for less than 5 months and you meet some other requirements, USCIS can fix your student status, put you back in student status without you leaving the United States. One big exception to that is if you've worked without authorization, you cannot apply for reinstatement. Well, you can apply, but you're just not eligible. So the own government's policy from the ICE website that describes a student visa program says basically your pretty much only option if you've worked without authorization as a student is to leave the country, is to get a new I-20, pay the status fee again, leave the country, and re-enter. And people come along and they ask me, well, Brian, if my school doesn't know about this and they're not terminating my service record, do I really have a problem? And the answer is yes, because one, even if the government knows or not, technically speaking, your status is broken, you are out of status, that's a problem you have. Secondly, in U.S. immigration, most anyway, student visas, you're not allowed to have intent to apply for a green card, but fun fact, I bet anybody most people in our audience who are seeking an employment-based green card now have probably been on a U.S. student visa in the past. And eventually, when you get that question on your I-45, your green card application, they're going to ask you, have you ever worked in the United States without authorization? And your answer has to be truthful. And, fine, people choose to be untruthful about these things, but that's a really darn risky endeavor, because if you are untruthful and the government knows about it, and they can deny your green card for fraud or misrepresentation, then you have a much bigger problem. So basically, sort of my general advice on anything like this is you have to hit these things like head on, because eventually you're going to get asked about it, and you have to be honest. And if you have to be honest, and if you're dishonest and the government finds out, boy howdy, you're going to have a bad time. Let's see here. Maybe take one more question and wrap it up for the evening. Now, if my wife was in the audience, she'll definitely tell me to wrap it up for the evening so I can come home and we can eat some dinner. Let's see here. Here is a great one. And maybe I'll wrap up on this one. How long does the interview take? And this is, I presume you're referring to the, you're referring to the green card interview, because citizenship interviews are usually a lot less interesting. So how long does an interview take? It really varies based upon the type of case you're at. Sometimes I have traveled, for employment-based green card interviews and been in and out the door with my client in, like 15 minutes inside the officer's office. Everybody's happy, green card approved later that day. For some employment-based cases, I've been in there with an hour with my client getting some really intense questions getting asked. Family-based case, I was just downtown here in fabulous Columbus, Ohio, at the intersection of Broad and Cleveland where the USCIS office is, and I got, an hour of questioning for my immigrating client. This is a family case, and, about 10 minutes of questions for his spouse. It can really vary all over the place. It really depends upon what the government's thinking about coming in. Sometimes, as far as I can tell, immigration interviews, green card interviews are just because sometimes we we check on people. Sometimes we do that, but sometimes they are really interested in you and you are stuck there in the office with USCIS for quite a long time. That's for sure. Well, that's it. It's 6:35. I think my goose is cooked, my pumpkin has popped, my cow has left the barn for the day. I'm going to see you guys back here with my friend and partner Sam Shihab Monday at 6 p.m. next week. And remember, get those questions into immigrationquestions.us for us because we do love answering them live here. Wishing everybody the absolute best. Have a fantastic week. Stay cold, warm, or dry wherever you're at.